Thank you, Mr. Speaker. One of the legacies of being a politician who was once a lawyer, like all of those who have spoken so far, is the unique perspective we bring to the debate on the separation of powers. Now, I'm not going to give any work experiences unlike Mr. Bridges, but what I do want to focus on is the boundaries between the executive, the judiciary and the legislature are an essential hallmark of our constitutional system. It is fundamental to this framework that the judiciary be publicly accountable for the administration of law, while the sovereignty of Parliament should remain intact. And in this bill, we bring the two together. The aim of the bill is to amend the current legislation to enable the appointment of a Deputy Commissioner, who can perform the Commissioner's functions when the Commissioner has a conflict of interest, is absent from the office or is incapacitated. Due and proper judicial conduct is about maintaining judicial independence and integrity, and this amendment does exactly that. And so we're not surprised that the New Zealand Bar Association provided general support for the bill in the respect that it aims at maintaining and enhancing public confidence in the judiciary. The association was particularly supportive of the provisions which result in a more transparent process to deal with complaints about the conduct of judges. Before 2004, if anyone complained about the conduct of a judge, it was referred to that judge's chief judge, who would take such action as the chief judge thought fit. It was an informal procedure without any statutory base. The old way was thought to be out of touch with the modern age, and so an independent investigation process was set up in 2004. Today's amendments emerged from that process. I want to make a clear distinction here between those that would criticise the utterances of judges as coming from the school of judicial activism and the absolute right of judges to express an independent view. This House will be well aware that over the last decade the judiciary has become under attack from successive administrations. The first swipe came from Margaret Wilson's description of Dame Shana Lice as the judge's shop steward. The second was now the new Attorney General's Michael Cullen's challenge against judicial activism. Indeed, so commonplace has it become for politicians to criticise the judiciary that retired Māori Land Court Judge Heta Hinkston concluded, and I quote, "Attacks on the judiciary have become par for the course since the 2003 Foreshore and Seabed Court of Appeal." The point I would raise here is that we must be careful to ensure that when considering complaints against the judiciary, we consider them as based on the genuine assessment of inadequate or inappropriate conduct, rather than simply because we disagree with the things they say. Judges have been criticised for misconduct, and so they should. It is only right and proper that inappropriate behaviour should be open to scrutiny, but it should not be a free-for-all. The Principal Family Court Judge, Peter Boshier, in a speech published in Butterworth's Family Law Journal in 1999, raised an interesting question which tests this out further, and I quote, "After all, what would the public rather have? A statute firmly set in the social mores of the 1970s, or a statute that lives and evolves within our society? Law does not exist in a vacuum, but is an evolutionary process. Development of the law is dependent on counsel being prepared to push boundaries and challenge judges to find ways to flesh the bones of the Act and do justice to all parties," unquote. I believe we need more judicial activism, not less, that we should welcome the opportunity for the law to evolve in ways which meet the needs of our changing society, and that to do this, we need judges who have demonstrated integrity. However, it is one thing to act with independence and integrity. It is quite another to act in ways which could serve to threaten the very foundations of justice. The Māori Party believes there must be some mechanism established to be able to identify judges whose sentences are so consistently harsh that they may be seen as criminalising youngsters without sufficient consideration for their rehabilitation. Anecdotally too, we have all been told the stories of judges who treat the so-called underclass much more severely than they treat offenders from the overclass. Sometimes conduct which does not seem overtly serious in the particular case assumes the appearance of bias when it is so consistent as to demonstrate a pattern. Perhaps then there should be room for complaints about conduct based upon a judge's overall record. The role then of the Judicial Conduct Commissioner is critical. The Commissioner, in carrying out an investigation of all complaints against judges, is a vital means of upholding the dignity and the integrity of the role of the judiciary. Such a role is a critical safeguard to ensure the principles of judicial independence are upheld and valued by all. And of course we recognise that within these amendments there is now the possibility that the Judicial Conduct Commissioner, in addition to existing remedies, may decide to take no further action on a complaint. Another feature of this bill is that it makes the necessary amendments to increase the size of the judiciary across a number of levels. The Judicial Act 1908 is amended to raise the maximum number of associate judges who may hold office at any particular time from 6 to 9. There are other amendments which increase the resource going to district court judges from 140 to 156 and to increase the number of Court of Appeal judges from 9 to 10. We note too the very wise advice of the Wellington Women Lawyers Association, who have recommended that the bill be amended to provide for permanent part-time appointments, with a provision that a part-time judge may be appointed on a full-time basis at a later stage on a vacancy arising. It was their recommendation that the bill should enable an opportunity for an application to work part-time on the proviso that, following advice from the relevant head of bench, that the approval will not unduly interfere with the ability of the court to discharge its obligations in an orderly and expeditious way, there should be no impediments to introducing such an approach. I will be interested to hear back from the Minister specifically about these proposals for part-time provision to enable a more flexible and supportive workplace environment. Mr. Speaker, due access to justice, the right to impartial and equitable treatment from the law, and the commitment to fairness is what drives us in taking that extra look at this legislation. We are satisfied with what we see at this reading, and we are pleased to add our support. Kia ora.